Men and women born 1956 to 2000.
We can start. We are live. Thank you.
Good evening to everyone. Welcome to the Drug Treatment Court Conference. It is Friday 11, 2022, and some of us are in Canada, some in Cyprus, and some in my home country in Greece. Some registrations, though, suggest that some other are in other countries, in Europe, and more. This is the first conference in Cyprus dedicated to drug treatment courts. For quite a few years now, me and my team have conducted research on drug courts operation, and I have publicly argued for the establishment of a pilot court in Cyprus and Greece. It is an honor for the law schools of the University of Nicosia and the Faculty of Law of Aristotle University of Thessaloniki to welcome here with us the Honourable Minister of Justice and Public Order of Cyprus, Mrs. Stephie Drakos. It is important when state authorities engage with new ideas for the criminal justice system. Now, I will welcome our speakers, and I will start with our legend, Honourable Justice Coffee Barnes, the judge who was the co-founder of Canada's first drug treatment court in Toronto in 1998. Whenever you look for information about Canadian drug courts, Coffee Barnes is the first expert in the field. Jennifer Crown is an assistant Crown attorney who shares passion for criminal justice. It's so important that she can give us her perception of what it means to work in a drug treatment court as a prosecutor. The most respected mental health and addiction center in Canada is KMH. And who is there? Robin Cuff, the manager of the Toronto Drug Treatment Court Treatment Program. Today, she's with us. What a pleasure to have Robin to share with us her views on addiction and crime, where we were and where we are now. And while everybody would say, well, this is a very good team, criminal justice systems need defense counsel. And here with us is Lorne Subsay, an experienced trial lawyer in criminal cases. He will share with us the client's perspective and counsel's perspective. It's important to note here that I'm using the word client, not criminal, not accused. Let's start now, and please keep notes for your questions. It will be really a fascinating experience to have these people with us. Now, I will call the Minister, Mrs. Drakos, to address the conference. Mrs. Drakos, the virtual floor is yours.
Honourable Judge Coffee Barnes, Dean of the Law School of Aristotle University, Professor Ellie Simenoidou Castanidou, Dean of the Law School of University of Nicosia, Professor Achillea Milianidi, distinguished guests, dear participants, good evening, everyone. Allow me to start by expressing my great pleasure and honor to be among such a distinguished audience. I would like to thank the School of Law of the University of Nicosia, and especially the Associate Professor Dr. Dimitra Sorvachoti, for organizing the first conference in Cyprus about drug treatment courts. I also extend my gratitude to all distinguished speakers and judges who are here today to share their knowledge and experience on this topic. drug treatment courts that were established in various countries, mainly in United States and Canada, they have been shown to operate with positive results for the health and well-being of individuals and communities. In case of the treatment of drug users, they also work as a bridge between criminal justice and health services in the community. They offer alternative to incarceration while providing offenders with an opportunity to receive therapy, treatment, and rehabilitation. Today's conference offers a great opportunity to exchange views and initiate a discussion on whether drug treatment courts would be for the benefit of our society also. It is noteworthy that over the last few years, several steps have been taken in Cyprus to promote therapy and recovery for drug users involved in the criminal justice system. According to the law, which came into force in 2016, while a court case is pending for judgment, the court, based on an individual assessment by a scientific advisory committee, may decide to refer a person with a drug abuse problem to a therapeutic center. When treatment order is issued, the hearing of the case is postponed until treatment is completed. Undoubtedly, the judges have an instrumental role in supporting treatment, therapy, and rehabilitation of drug users involved in the criminal justice system. With this in mind, I had recently the opportunity to discuss this issue with the director of Judicial Training Academy and have requested to include a special training course for the judges regarding the treatment of drug users. In conclusion, I extend my very best wishes for a very successful and fruitful conference. Due to other commitments, regretfully, I will not be able to remain with you and follow this very interesting conference. However, I'm looking forward to its conclusions, which will provide a rich source of information and knowledge and mark the beginning of discussions on the need of, as I said before, establishing also here in Cyprus such an institution for the benefit of society and individuals. Thank you once again. My very best wishes for every success.
Mrs. Drakos, thank you very much. Thank you. Now we will start, and I will go to our first speaker, Justice Barnes. Justice Barnes? We cannot hear you. Can you please mute?
Yes. So now, good morning, and thank you very much for the invitation. It's good to know what I do now, right? And what I can tell you is that what I do now is that even though I'm one of the founders of drug treatment courts in Canada, I am one of the people who continue to push and examine drug treatment courts to continue to improve the model to ensure that we achieve the very, very best results on a regular basis. So I'm not biased. In fact, in talking to you today, I'm going to make some fun of myself. I'm going to explain to you what I used to think about drug treatment court. Now, you have to understand what I do today, right? Right now, I am a judge in the Superior Court. I'm no longer a drug treatment court judge, which means that I deal with the most serious cases in criminal, commercial, family, estates, so a broad range of Canadian law. And one of the things that I do to keep myself informed on what's going on is that I do a lot of training, I do a lot of listening, I learn about drug treatment courts, I help the area evolve. And over the last 25 years or so, I have been traveling to over 20, I was trying to count, over 20 countries across the globe, many of them more than once, learning from others, teaching, and continue to hone my expertise in the area. And I want to tell you, I didn't always think drug treatment court was a good idea. I'm a prosecutor, right? And in fact, when I was growing up, I even never saw drugs. I don't know what drugs was. So far as I was concerned, if anybody is using drugs, it's because they have got a problem. They are too weak. They don't have the strength. I mean, and they cause all kinds of trouble. So in 1997, I was a prosecutor working in a courthouse in Toronto, and my late friend, my co-founder, the guy whose idea this was, Justice Paul Bentley, said, look, we have a problem. We have these drug addicted offenders who keep coming before the court on a regular basis. It's clear that they will steal or rob. Sometimes they'll terrorize victims and sell or exchange items that they steal or get for the purpose of supporting their drug habit. Sometimes they will sell small amounts of the drug so that they can get some drug from their dealer so they can actually feed their habit. Many of these people are homeless. They're unemployed. Because they don't have a chance to take proper care of themselves, they use the health system excessively. These are people who are arrested by police either for a drug offense or for a non-drug offense. They are charged, they are jailed, all at taxpayers' expense. And then what happens as soon as they're released? They go right back to the same place. The shoppers, the business people are frustrated. They are saying things like, listen, why do these people keep coming back? You arrest them, you put them in jail at the taxpayers' expense. It makes no difference. They come out. The police officers are frustrated. So we knew we had to do something because we needed to keep our resources for the big time dealers, the drug cartels, those kinds of people, right? So I was all for this. Then Paul Bentley said, we were now going to bring treatment. Ladies and gentlemen, we're going to bring treatment into the sacred halls of the courtroom. Now, those of you who are legally trained, can you imagine how that felt? I was like, has this guy lost his mind? This is not going to work. I mean, there's going to be total chaos. I mean, drug users were going to abuse the system. This is a total and complete soft on crime approach. I thought it was a bad idea. But you know something? I was so wrong. I mean, in fact, I could not believe my eyes when there were some people who say, Your Honor, send me to jail, please. Send me to jail. I'd rather go and stay in jail under the taxpayers thing and at least I'll get out because it's too hard to change my life. I was shocked. I was like, what is going on? And then soft on crime. Oh my God, hard on crime or whatever you want to call it. I was surprised to find out. You know something? People in drug treatment court are the most supervised, non-incarcerated people around. At the same time, engaging their holistic rehabilitation. I mean, I was shocked and surprised that police officers, victims of crime, families being reunited, people are like, oh, you guys are doing great stuff. And in fact, I was like, it was so smart because we started as a pilot project before we tried it out, pilot program. And I was seeing results that I did not understand. We had a chance to work it out. And then another thing that I also thought was that people, the reason why they get involved in drugs that they don't have any determination. So we're just going to set up a program, get them to do it, and in 6 months, they will be fine. Well, and then, so I figured that's all we had to do. Well, I was wrong on that too, and I'll tell you why I was wrong. And then what blew my mind was that treatment providers were saying things like, hey, look, don't sanction them for using drugs. Just focus on their behaviors and their accountability. Make sure they make the appointments. Get them to be honest. That also didn't make sense to me as a prosecutor. I was telling myself, oh my God, what does this mean? I mean, total chaos on the streets. I mean, crime. Oh my Lord, what's going to happen? Then I found out, to my shocking surprise, that this whole collaborative team, the judge, the defense lawyer, the prosecutor, the treatment provider, probation, even the police, because they work together and share information, they all get to bring together. You see the same offender or the same client has different sides. And as they get together and they share their viewpoints, and they all have rehabilitation on mind, all of a sudden, they're able to engage in holistic rehabilitation. Oh my God, to my shocking surprise, all of a sudden, these people were performing. They were not committing crimes. What is going on? I did not understand. And then I also thought all you had to do was set up one set program for everybody, you know, and if people don't do it, you just put them in jail. You know, again, I was wrong. It turns out that addiction affects people differently, right? You know, there are different measures of success. There are some people who will stop the crime, reduce the crime, but maybe they still cannot get a job. They cannot go back to school, right? But the crime has stopped. There's some people who can do all those things. Some people can get clean in 6 months. Some people need more time. I was like, what is happening? Because as a prosecutor, I'm thinking, if you don't get off drugs immediately, you are committing crimes, back to jail. I was wrong on that. Another thing too that I also learned, that in fact there's something called trauma. What the heck is trauma? I mean, trauma is just an excuse, I thought. Trauma is just an excuse. I mean, I'm a prosecutor. What do you mean trauma? This guy is weak. No, I came to realize that most people are going through traumatic experiences. And a traumatic event in their lives. Some of them, they're using the drugs to mark things like mental illness and other issues, you know, and so it became clear that, you know, when we're going to deal with the drug addiction, we have to have so many community partners, because once you get on the drugs, oh my Lord, all kinds of things come out that you have to deal with. I'm thinking, well, how are you going to do that, right? And the drug treatment court system helps you connect with different resources in the community, and I was amazed on how the system works, and as you are getting different agencies to work together to achieve what we call holistic rehabilitation, you need an effective case management and process. Now, at this moment in time, I think it is good to just watch a video to give you a sense of what drug treatment court is about. Let's just hear one person's perspective, and then I'll come back and we'll continue, right? So Dimitri, let's have that first video just to give a sense of what we are talking about.
I came from a really good family. I'm one of those people who, if addiction is linked to some sort of pathology in the family, I shouldn't be that guy. But for some reason, from a really young age, I was profoundly filled with anxiety. And I was really worried about everyone. And every time I would hear about some problem in the world, that problem touched me a little too closely. And I'll never forget, the first time I snorted heroin, everything changed. It was like a huge exhalation left my body. And all the stress and all the fear and all the things that I was worried about just sort of washed out of me. You know, and I came up in that just say no generation where people were saying drugs are dangerous. And I had done cocaine, I'd smoked a bunch of weed, and I tried LSD, and I dropped a lot of mushrooms, and none of these drugs seemed to me to be as dangerous as the propaganda was trying to communicate. So I assumed when the heroin was there that this was just another drug that the government was trying to keep me away from. By the time my addiction brought me to the criminal justice system, I'd lost my car, lost my job, I was homeless, I'd lost all my friends, I'd lost the respect of my family, I'd lost my self-respect. I mean, I had nothing. I had been, at that point, through 4 different rehabilitation programs. I'd locked myself in rooms and gone through 7 or 10 days of withdrawals and come out ready to go with the world. And every time, no matter what I did, even when I picked myself up and moved myself to a new city to get away from heroin, I always ended up going back to it. You remember, I was put in the Denver City Jail, and eventually a public defender, an attorney, came in and he sat down with me and he said, "We're offering you something called drug court. These days they're starting to be called therapeutic courts or treatment courts." And they came about because people in the criminal justice system started to realize that Addicts they were telling not to use drugs, and addicts they were giving second chances to were coming back into the system over and over and over again, and eventually were being thrown into prison by judges who didn't necessarily feel like they should be there. And the idea was this: we're going to bring people in the criminal justice system and we're going to require them to get treatment. And we're going to try to be understanding of addiction in an intelligent way. First of all, they understood the fact that I was going to relapse. And so when I relapsed, there would be a sanction for it and there would be a treatment response for it, but they put me back on probation. There wasn't this constant threat of prison. And I had a judge who would see me every couple of weeks. He made it very clear that he believed in me and he expected me to get through this program. Additionally, maybe most importantly, they allowed me to do methadone. Methadone, for those of you who don't know, is an opiate, an opioid, a synthetic opiate. It allows addicts to forget about heroin for a little while so they can concentrate on treatment. The other really important thing you should know about methadone is it makes the individual much less likely to die of an overdose. But methadone, the structure of methadone and treatment in conjunction with methadone and the pressure that was put on me by the court allowed me to start to put pieces of my life back together. So what I want to say is opioids are not the problem. Opioids are a problem, undoubtedly. But what we have in this country at this point is an addiction epidemic. Being a drug court magistrate now, I have addicts parade in front of me all day, and I see many of them, many get clean and say, I believe I can do this on my own. And it is so rare. But the ones who will lean on medication-assisted treatments are the ones who seem to be able to walk away from their addiction most successfully.
All right. Now, I understand that there's a lot of static. Are you still getting a lot of static? Is it better now? Okay, so it's better now. Okay, and I will see if I can control that. Now, it's still bad. Interesting. I have no idea why
It's worse right now.
Not better. It's worse.
Yeah,
Okay.
not better.
It's still bad.
Yeah.
I don't know what's causing it because everything here is. It can be indicated a little bit. I'll try to do so. Okay.
Okay, never mind. Maybe we can go on and.
That's most unfortunate. Okay. Is there static? Is there static when the video is playing?
Yeah. Yeah.
Oh, there is. So there's no solution there either.
So maybe if later we can use headphones. It's not that. Oh, maybe now. I think it just goes.
Let me see if this helps us. Is it any better?
No.
No.
Oh, now it's better.
Oh, wait.
Is it better now?
No.
What? No.
I can hear you now.
Yeah, no, it's the same problem. So probably it's
Same
from,
problem.
Yeah.
Okay.
But we can
Because
hear
I'm
you
now-
better. But we can hear you better right now, I think.
You can hear me better?
Yes.
Okay. I'm going to continue then. And sorry about this.
No, it's fine now. There's no noise. No, it's fine. Thank you.
No
Thank
noise, right? Okay. And it was fine with the video too, no noise? I mean, I don't know. We'll see how it goes. All right. Video was so. Well, listen, it's unfortunate because I've said a whole bunch of good stuff that you've not heard, which is unfortunate. But this is what I'm going to say to you. Because I'm going to change my whole presentation because you didn't hear me, right? Okay. The drug treatment court program is designed to address the issue of what we are dealing with, and that is addiction. One of the things that I realized when I started to work in drug treatment courts as a lawyer was I did not understand what addiction was, right? And so as a result, I made certain assumptions. And those are some of the things I talked to you about. Because I did not, because it was common sense, right? If you try to treat addicts who are committing crimes in the community and you don't send them to jail, they're just going to cause all kinds of crazy problems, right? If you don't punish them for the fact that they're using drugs, they're going to cause all kinds of crazy problems. Well, I was wrong, right? I realized I was wrong. In fact, by applying the drug treatment court principles, we actually ended up seeing a reduction in crime, better lifestyle, and better lives. And so it occurred to me, I was like, why is this happening? Then I realized that, listen, if you want to understand why a system is happening, you have to understand what the issue is. Nobody taught us in law school what addiction is, right? So then I learned that addiction is a chronic disease. It is a disease that is characterized by drug seeking and use. It is compulsive. It is difficult to control, despite the harmful consequences. Also learn that changes happen in the brain over time, and those changes affect a drug addicted person's self-control. It interferes with the ability to resist the intense urges to take drugs. That is why drug addiction is a relapsing disease. And that's why my whole concept of, well, why can't they stop makes no sense, right? And then I also learned that relapse is a return to drug use after an attempt to stop. People actually try to stop, but for biological reasons, they can't. And the relapse indicates the need for more or different treatment. That's why I my initial comment to you that said, why don't you lock them up? Doesn't work, right? Because once you understand addiction, you realize that it doesn't follow common sense. It's like having an illness. If you've got something in your body that requires surgery, you don't apply common sense. You apply the medical principles. It's the same thing with addiction. And what happens is, as you use drugs, the brain's reward circuit is affected by the drugs. It floods it with a chemical messenger called dopamine, and that surge of dopamine in the reward circuit causes reinforcement of pleasurable but unhealthy activities. That is why people do it over and over again. That is why they can't stop. I was like, wow. See, now it's beginning to make sense. Because as a legal guy, I'm thinking this is all pure nonsense, right? It's not beginning to make sense. And then over time, what the brain will start to adjust to the excess dopamine, and then it will reduce the thing that makes the person go high. When you never get the same high the first time. And so they will take more and more of the drug trying to achieve, and the drug gets more and more expensive. They commit more and more drugs, more and more crime, right? And so you also realize that there's no one single factor that predicts whether a person will become addicted to drugs. Like, for example, the person who just listened to the magistrate, he was a person who came from a good background. Right, there may be genetic or environmental factors that influence the risk for addiction. And addiction, when treated, is treatable and can be successfully managed. That is why the drug treatment court method has 13 key principles. These are principles that you apply, and you can change them to fit your particular environment. So there's effective judicial leadership. There is strong collaboration amongst members of the team, so you have a more holistic type of intervention. There's good knowledge. People have good knowledge and understanding of addiction and recovery by the non-healthcare professionals, because when you have that, all of a sudden things start to make sense. There's usually some kind of operational manual somewhere to ensure that people are on the same page. There are clear eligibility criteria, which ensures consistency, and people who come to the program are assessed in a detailed way. There's documents that indicate there's informed consent, so everybody knows what is going on. Try to get people into treatment as soon as possible. There are some consistent sanctions and incentives that are therapeutically based, that are designed to achieve holistic rehabilitation. There's also ongoing evaluation, which enables programs to tailor and meet shortcomings. You try and get some funding, and also you assess how your procedural law can make it work. and see if there are any changes. And you have to adhere to these 13 principles, which can be adapted depending on the circumstances of every place. Now, why do we do this, right? I mean, why drug treatment courts? Well, drug treatment courts because of results. In Calgary, there was an evaluation that was done. 42% of the people that went to that were in the Calgary drug treatment court, 42% of them were homeless. 82% of them were unemployed. 89% of them were making less than minimum wage, or if no money at all. 100% of them were committing crime to buy drugs. And 72% had suffered some kind of childhood trauma. 89% of them were at risk, high risk to reoffend. And 73% of them had high needs. That is homelessness, unemployment, and a whole bunch of other personal issues, right? And after looking at those people over a 4-year period, they found that 76% of them did not commit an offense. Now, this is huge, right? And then you think about cost savings. If they analyze that, if you think about the amount of money that was saved by avoiding all the thefts and so on and so forth, it was between $15 to $20 million, right? And if you think about the amount of money that was saved over that period of time in terms of cost saving from incarceration, there was $7.4 million. And this is the why. And also on a personal level, when you see somebody who is a drug addict, who has gone through the process over and over and over again, and then you see them transform before your eyes and become productive members of society, you say, wow, right? And that is the reason why this skeptic is a believer. And that's the reason why I travel all over the world. I encourage people to have pilot projects, and we see results. Now, Dimitra, should I wrap up now? Because I've got one more video, but I could wrap up now. Not, should we play it? Yeah? Okay. Let's play the video, and hopefully there's not too much static. Let's just wrap this up with the video.
Public health crisis. We cannot solve this with incarceration. Drug courts are part of the solution. Drug courts, also called treatment courts, are specialized court programs for persons with substance use disorders. Instead of simply going to jail, the programs give people the opportunity to enter long-term treatment and agree to court supervision. Drug courts address the root causes of drug use and criminal behavior, like poverty, mental health issues, physical health, and unemployment. Participants in drug court maintain recovery from drugs, take on responsibilities, and work towards lifestyle changes. Members of the court help participants in their progress towards these goals and hold them accountable for lapses in improvement. Unlike traditional court, drug courts take a collaborative approach to justice. The judge, prosecutor, defense attorney, and probation official work collaboratively. As a team, they use their individual expertise in partnership with public health professionals, such as treatment providers, social services, and mental health specialists. Together, they seek solutions that benefit the participant. Ultimately, drug courts reduce crime and affect real change in lives. To be eligible for drug court, a person must be charged with or convicted of criminal drug or related charges, be likely to reoffend, and are experiencing serious substance use disorders. There is no universal model for drug court programs, but there are two common ways in which people enter drug court. One in which defendants who meet eligibility requirements are diverted from traditional court proceedings into drug court prior to pleading to a charge. The other, in which defendants who meet eligibility requirements plead guilty to their charges and their sentences are deferred or suspended while they participate in drug court. In many cases, participants who successfully complete the drug court program may have their underlying criminal offenses dismissed or expunged. If a participant fails to complete the program, their case will be processed as it normally would in the traditional criminal justice system. Drug court is an intensive program. It requires immense commitment from participants and dedicated case supervision from the drug court team. The program often includes participation over a series of months or years. This establishes and helps maintain long-term recovery strategies. Frequent and random drug tests. Drug tests are a way to establish accountability and integrity in the effort to stay sober. Treatment for substance use disorders. These treatment programs are grounded in the science of addiction and evidence-based models. Required frequent appearances in court. This gives structure to participants' lives and integrates them into a community of recovery. Immediate rewards for maintaining treatment plans and sanctions for failure to meet obligations. Individualized case management services, connecting participants to employment opportunities, community service, pro-social activities, and education, and support and encouragement from the drug court team. Drug courts can be tailored for specific populations. There are courts specifically for DUI, DWI violations, courts for opioid use disorders, courts for juveniles with drug dependency, and courts for veterans. Drug courts are operating with incredible success across the country. They are effective at getting people into treatment, a key step in long-term sobriety. People who complete drug court programs are significantly less likely to be arrested again compared to those who are sentenced with traditional punishments. The most successful drug courts reduce recidivism by as much as 35 to 40%. Drug courts are also cost beneficial. The National Institute of Justice concluded from a decade-long study of a drug court that reduced recidivism and other long-term program outcomes resulted in public savings of $6,744 on average per participant. We know drug courts enhance public safety, save dollars, and most importantly, restore dignity to individuals, families, and communities. In the words of Judge Thomas Horn of Loudoun County, Virginia, drug courts are the single most powerful and innovative tool available to the criminal justice system in the fight against drug abuse. To learn more, visit ndcrc.org.
All right. I'm going to wrap up by just making this one comment, right? So what you've seen, you've heard that drug courts started in the U.S. And what we did in Canada, and what is a process that I suggest all over the world is we understood the principles and then we adapted it to our own circumstance. I've traveled around the country, to so many different countries, and many times, and I will talk about it later, we've had workshops when people are trying to see whether or not drug treatment courts can work within their legal system. And for some reason, when I'm walking the rooms in different countries, I find, and I do not know why, I'll have to leave this to a psychiatrist to tell me, or psychologist to tell me why, but I find that how you frame the question is very important. So if you ask yourself, will our legal system allow us to implement this court? Many times it's seen, I do not know why, many times it seems very difficult, particularly in continental countries and other countries, right? When we're doing that in Canada, when we ask ourselves that question, for some reason it didn't seem to work. I do not know why. We saw all kinds of roadblocks. But when we ask ourselves, but if we did it reverse and said, okay, fine, we are going to try and understand the 13 key principles of drug treatment courts. Once we have understood it, through that lens, we are going to look at our legal system. It is amazing how that backdoor approach solves all kinds of problems. Because when we did it that way, all of a sudden in Canada, we could see all kinds of ways of doing it within our system. Not because our system is different from the US. In every country I've been in, I've been to several, that is the way it was done. In Belgium, that's the way it was done. And Belgium has a civil system. In Mexico, that's the way it was done. And whenever you do it that way, all of a sudden, you start to see things you don't see before. Anyways, I'll keep quiet. The other people who have to speak today, thank you very much.
Justice Barnes, thank you very much. Well, I think I'm going to keep two things that you said in the last 5 minutes. Wow, the person can change, performs better now than before. And this really weigh out how we can find ourselves to meet these principles in the justice system and then reach the whole idea of the therapeutic jurisprudence and drug treatment court. And now I will move to Jennifer. Jennifer, let's see, what do you see in this system? And what is a prosecutor's view? Because especially in the common law system, usually the prosecutors have a burden to prove guilt beyond reasonable doubt. What do you do in a court like this?
Thanks so much for having me and for this opportunity. I have to say, jumping off of what Justice Barnes has just shared, creativity as a prosecutor is challenging. It's challenging personally and professionally to try and figure out how these types of courts fit into what we think court should look like and what it could look like if we open our minds to thinking different ways. And I have to say, and I know we'll get to it later, the time that I've spent in the drug treatment court in our jurisdiction has been the most rewarding time that I have spent in any court dealing with very serious matters. And we'll get into that a bit more. But I wanted to share, given that we come from different parts of the world, that we have two main prosecutorial services here in Canada. So I work for the provincial government as a representative of Her Majesty the Queen. And my role is to prosecute criminal code offenses. So basically that's everything except for specific drug offenses, which fall under a different piece of legislation. So we work closely with a different prosecutorial service who's also a part of our court. But things that fall under criminal code offenses are thefts, mischiefs, driving under the influence, breaching court orders, all the less serious offenses. And it goes all the way up to the most serious offenses, that being of murder, treason. There's a ton, but they're escaping me right now, but the most serious offenses. So rest assured to perhaps people who are a little apprehensive about these types of courts, that they actually work twofold to serve the community in prosecuting the most serious offenses. The first is those offenses don't come into our court. So we have, we deal with the thefts, the mischiefs, the nuisance offenses, the fraud offenses, low-level frauds, those sorts of things. But the other way that it helps society, in my opinion, is that it opens the courts up to deal with the most serious offenses. So there's more resources that can be allocated to doing a murder trial, doing the most serious things that we would all agree ought to be before a jury or a judge. So as I mentioned, my role generally as a Crown is to prosecute those all those types of offenses. My role in the drug treatment court, however, honestly, is to be a cheerleader. Now, the reason I say that is for the clients who have the courage to seek help for their addiction, first of all, that's a huge step for them. And second, when they do succeed, which I'll get into in a minute, the rewards, both from a societal perspective and a personal perspective, are exponential. I want to say to just kind of set up a bit of context. So I work in the Peel region, which is just outside of Toronto. We're the largest jurisdiction in all of Canada. So we have a lot of matters that are coming before all levels of court. We have a large problem with substance use, and we have thousands of these nuisance property offenses that are coming before the courts. And there is definitely a nexus between the substance use issue in our region and these types of low-level offenses. The goal generally in getting, besides being a cheerleader, I was half joking, but I do see that as one of my goals. But the goal, putting my strictly Crown hat on, is to get matters through the court as quickly and as fairly as possible. And I take that seriously and move that over to drug treatment court, and the goals are added that we are reducing the cost to the courts and we're reducing the price to society. So the way that we do that, if we look at a typical prosecution, okay, in Canada, we proceed on what we call an information. It's a charging document. And in order to have a trial on a particular charging document, you need to have a whole bunch of different players. So you're going to have a prosecutor who needs to present the evidence. We have a judge or a jury, but a judge on an information who's going to adjudicate. You have police witnesses, civilian witnesses, defense counsel. There's a lot of players that are involved in a trial. And if we're able to take these low-level offenses and move them into a drug treatment court where the person, the client, is wanting to get help, all of those resources can go to the trials that need to be adjudicated. So we don't have all of those resources for all those different players that are going towards trials for matters where, in my opinion, aren't worthy of that type of court time. I wanted to make a small mention, but I think Robin may go into it a bit more later on, that we in Peel, but not all across Canada, are a harm reduction program. There are programs in the country that are based on abstinence. There's varying opinions on that. It works for us. And I'll explain a little bit about that. So, oftentimes we're asked, how do you measure success? How do you measure success for a client? It's really challenging, to be honest. It's challenging because every client is different. It's challenging because stats are hard to keep. And those are difficult because most of our programs are not funded. So we don't have statisticians to assist us, generally speaking, on keeping the particular stats. But for me, success isn't measured in the stats. It's measured in the following ways. Has the client been able to become substance free? That's obviously a journey, which I know Robin will speak on later on. But what is also included in that, for me and for our program, is, has the person been able to secure stable housing? So if they're able to find someone safe and secure to live, we have found that their successes in the program jump up exponentially. I'll give an example in a few minutes about one of our clients who had that very challenge and how that has affected her. Another huge success is whether or not the particular client has picked up new charges. So while in our program, have they incurred further nuisance charges? And sometimes they do, and that's okay. And oftentimes they don't. I want to say that if they pick up or incur very serious charges, those charges do not come into the program. And unfortunately for that particular client, it usually means that they remain incarcerated and can no longer continue in the program. But I digress a little bit. So there's another success is also a reduced seriousness of charges. So are the number of charges going down, and is the seriousness of the charges being reduced? And obviously there's gains to be attained through in the therapeutic realm, and those are successes as well. So the ultimate goal in our program, and I'm sure all programs across the country, is to get to a substance-free place for the particular client. However, all of the successes that I've just laid out for you are celebrated, because success is different, as we've mentioned a few times, for each client. So I want to lay out what it means to get to graduation. It's a common question. So our clients must be substance-free for a period of time. It's usually a minimum of 3 months. And as I mentioned, they have to have stable housing. They don't incur further charges, and they're involved in their community to some extent, whether hopefully that's through gainful employment. It could be through community service. It could be through being connected to their counseling or programs that work for them. And we have found that sort of grouping of graduation criteria has been highly successful. And I can say, before I get into an example that I want to share, that since I joined the program here in Peel, which was 6 years ago, we have had only 3 graduates incur further charges after graduation. So, and I want to add that those charges that they did incur were still lower level nuisance type charges. They weren't serious violent offenses. And one of those 3 that graduated and picked up further charges actually came back. And he said, I don't think I was ready to graduate the first time. I want to try this again. And of course, having that insight was amazing. And of course, we accepted him once again. And he actually just graduated for the second time about a month ago, which was wonderful. So if you'd allow me, I want to share an example of one of our current participants. Obviously, I won't give any identifiers, but it's important to show you how we are saving money, which is important, both to taxpayers and to the system as a whole. So we have a female participant who, when she came into the program, was facing 66 charges on 19 different files. So 19 different charging documents, as I mentioned before. So if she had not entered our program on those 66 charges and 19 charging documents, that means there would have been 19 trials, 19 judges, 19 crowns assigned to prepare and prosecute, 19 sets of witnesses, defense counsel, probably one defense counsel, but they would have to prepare 19 times. That is a lot. I can't even imagine what it would amount to. My estimate, and maybe my colleagues here would disagree, was probably about 1 month worth of court time. And that's just to hear the trials alone. So that, to me, that amount of resource saving is very significant. So a little bit more about our client. In 2 years that she's been in the program, she has not incurred any further charges. That's a huge success. So never mind that we're not going through 19 trials. We don't have police investigating further offenses when it comes to her. We don't have further, whether it's a business victim, a personal victim, there's no further victims that are being affected. There's, the detention center doesn't have to house her if she's not released out of custody. There's a lot of savings in just not getting new charges over the past 2 years. A further success is she has significantly reduced the amount of use She's addicted to opioids. So there's a significant reduction in her use, which of course, I would argue, leads to less charges, less police involvement, less victims to society and those sorts of things. And what I would say is, and what she says is the most significant success is through our program, she has secured stable housing. So we have a housing worker that's attached to our program, and she was living, she was houseless for 3 years before she came into our program, and had not had a roof besides a jail roof over her head in 3 years. That's through a Canadian winter for our non-Canadian participants joining us today. So she had some significant challenges in that. So for us, that's a huge success. And again, I would argue that's why she has reduced her use. That's why she has not picked up any further charges. And it's just a snowball effect when you have these, what some people may perceive to be small successes for this particular client, even though she's not yet substance free. And while that is still her goal, the effect and the change this has had on her life, I don't think any of us could ever put into words. So that's my anecdotal story about one of our current clients. I've lost track of time. I apologize, but I want to add that this is not a typical role for a prosecutor, as Justice Barnes laid out at the outset of his comments. It can be uncomfortable. It can be challenging. It's a hard thing to wrap your head around when we're so used to being in this adversarial system where our job is to get dressed, put on our suit, walk into court every day, fight the good fight. But why do that when you can actually make a small difference in someone's life? And I'm not going to sit here and tell any of you that I was the one that made the difference. That's not true. The difference is being made by the client with mostly, I would argue, the assistance of the community partners, the treatment providers. And it's with our, as I go back to saying before, support, why my role is of being the biggest cheerleader for our clients. It is an honor to do so, and it's a privilege. And again, I know if there's any prosecutors listening, it is uncomfortable, but it's worth it.
So Jennifer, thank you very much. I think I will take two things from what you said. That, well, generally speaking, the traditional role is that for a prosecutor, success is when convicting, right? But now success is also when treatment is applied and someone reduces social harm and self-harm. So this is also success for the criminal justice system. Let's see now what Robin is going to say. The person that now, I mean, we know that with the drug treatment courts, treatment providers are in the court. They have a say, and they do a lot. So the drug treatment courts are actually these courts that they have bring you into the court, right?
Yes.
Let's hear what.
Okay, so first of all, we can't see the audience here today, but I just want to thank you. And I realize that most of you are joining us after the end of a long day on a Friday afternoon. So it's really great to be here with you here in Canada. Well, in our time zone, at least, it's middle of the day, noon. So thank you very much for coming. Secondly, I was smiling throughout Kofi and Jennifer's presentations because usually as a treatment provider, we're saying all of the things that Kofi and Jennifer are saying, but the difference is that they have been embedded in this system. So I think this is a good demonstration of how in drug treatment courts we keep our separate roles, but we overlap our roles because there is a common cause and a common understanding of what problem we're looking at, and also in some ways what success means. And I think that one of the biggest things in addiction treatment, but also in drug treatment courts specifically, is redefining success. Not success as, well, Kofi was talking about the things that he used to think and that he no longer thinks. And we don't really define success. The other thing I want to add is, and Jennifer was very humble about saying, she didn't bring the success. That's true. The clients are the ones that work on it. But the job of drug treatment court is to create an atmosphere in which clients will trust every player around the table enough to walk alongside them and help them. They give us permission to help them succeed. That permission needs to be earned. This is not the system where you come into the court and because there's all this power and authority that we expect the respect and we expect that you follow what we do. You earn the trust, and then the client lets down their guard and they start being honest and real, and they see that you are part. Every member of that team is part of their journey. One of the reasons, one of the things that we are really strong on is making sure wherever possible that all the players in the court and the treatment world are the same players as much as possible. And the very thing that I talked about, in addition to other things, but the very thing that I talked about is earning that trust is why. So in our program, when there's a fill-in judge or a fill-in Crown attorney, you can see the clients just clam up and they expect it to be the old system that they were used to, where they have no say. In drug treatment court, the client talks directly to the judge and directly to the Crown. This is a relationship, and the evidence shows that the relationship between the Crown, between the client and the judge, is one of the top success factors. So yes, as Jennifer says, it's a little uncomfortable. Jennifer also said that she's in a cheerleading role, and that is true, because part of what drug treatment court is altering the relationship between the client and the power authorities in their lives. And when they see that the judge or the Crown especially is praising them, they also will be more likely to accept when maybe it's not as much praise, but it's an admonition, because they say, and what our clients say to us, well, yeah, the Crown was tough today, but we know they have a job to do and they care. So they evaluate our motivation as much as we evaluate their motivation. So I first came into contact with drug treatment court back when Toronto was starting the first drug treatment court. I was not in drug treatment court at the time. I was not at the Center for Addiction and Mental Health. I was the executive director of a residential addictions treatment agency for women. And the judge, Judge Bentley, I kind of refer to him as a bulldozer with heart. He made things happen, and he summoned all of us to a community meeting to talk about drug treatment courts. And while Kofi and Jennifer have talked to you today about how odd or uncomfortable or how unrealistic some of these things may seem from a court perspective, let me tell you, from a treatment perspective, it was no easier. we spent a lot of time protecting our clients against the judges, the police, the crown attorneys, the court system, because we did not believe that they were treated humanely within that system. There was no understanding of their issues, their problems. It was very black and white, and pardon the pun, very legalistic. So we had to challenge ourselves to come along. And I remember my first thoughts: partner with the criminal justice system, talk about clients in front of crown attorneys? Not on your life. I am not participating in that. Our clients would never trust us again if we did it. So part of what we're doing here today is just mentioning a few of the highlights of how difficult this is. But I hope that what you're hearing from us is how very possible it is, and how very rewarding, and how it actually, in the end, really makes a lot of sense and makes a lot of difference. The title of this was The Canadian Perspective. And I will say to you that I cannot tell you the Canadian experience. We are a large country, and we have different systems across our country. So in many ways, and we'll talk about this a little later when Kofi and I talk about international experience, but in many ways, what's important is that everyone gain an understanding of addiction, how to treat people with substance use issues, how to understand the complexities that the clients come with, how to establish principles and remain true to those principles, and then how you adapt within all of those guidelines. I will say that in the United States, while they're changing some things, we inserted treatment in the middle of drug court on purpose in Canada, because treatment is the center of what we do. It doesn't mean we're more important, but without the treatment component, it is just a drug court that deals with drug issues. With the treatment component, it is a therapeutic process. So we are very strong on this, and you will always hear us doing drug treatment court, not drug court, because language matters and perception matters. We also, I will say, I don't want to be critical of our neighbors to the south. There's some amazing drug treatment courts there. There are some that aren't so good. And I would say the same goes for Canada. What I will say is that in the United States, they have lots of research on this. It is the most researched intervention in the United States. And we gather a lot of the research from them, but then we adapt it to our culture. And we have universal healthcare in Canada. They don't in the United States. That in itself, like, forget anything else, but that in itself makes our program and our process different. They have people who have marijuana use that have gone to, and marijuana possession that have gone to jail for 5 years. Here, we now have legalized marijuana, not just decriminalized, but legalized marijuana. So while we gather evidence and we adapt it, we have different cultures and different legal systems and different societal values. So that is important if you are going to do this in Cyprus or anywhere else, to recognize the context in which you are operating. Drug treatment court is what I call an ethical dilemma. In and of itself, it is an ethical dilemma. You have cases being discussed with defense and crown and judge in the room. Treatment is in the room. Treatment is sharing personal health information, not lots, but personal health information with the court system. It is just an ethical mess. And that is why we always pay attention to ethics. And I know that certainly with Kofi and I, with all the international training we've done, we've often done sessions on ethical concerns. And we are a small program within the Center for Addiction and Mental Health, which is Canada's largest addiction and mental health treatment and research center. We are a very tiny program, but we probably use our ethicist more than anyone does. And there's good reason for that. So we are always living in that. I will also say that while we see all of the roles overlapping, one of the things that's really important, and I will speak from a treatment provider's perspective, but others, you can adapt that perspective to others. It is so important for treatment within this model not to become an arm of the criminal justice system. And that is a danger. It is a danger for us to look at the power of the criminal justice system and start acting as if we have that power over the clients and start using that power over the clients. It is also dangerous when we start recommending sanctions. We are an information provider. So while the roles have to overlap, they also have to remain very distinct in many ways. So today we are just talking fairly informally to you. We want to generate discussion, but we also want to generate thought. Everything we've talked about, we have presentations, we've done presentations, each little thing, we've done full presentations on all of it. We do want to make clear that addiction is seen within this model first and foremost as a health issue. Yes, it crosses over into criminal justice and other fields as well, but this is a health issue that we have, our societies, yours, mine, other societies have criminalized it, and unfortunately it has criminal implications. We don't really criminalize any or many other health issues. We do with mental health quite frequently, but not many others. Certainly we don't criminalize broken legs, do we? So in our program, I'm going to give you just a very brief outline of how the program works, because I realize that we've been talking passionately, but not very specifically. So this will be very quick. It won't give you a lot of description, but that's what I will do. So in our program in Toronto, we have a designated treatment provider. Not all programs do. We also utilize other programs in the community because our clients have various needs. But what really happens here is a potential client gets arrested. They voluntarily, usually through their lawyer, apply to drug treatment court. The Crown Attorney reviews the case to make sure that the eligibility criteria is met. They usually look at it from a criminal charges perspective. We do not accept people who have violent charges, but we accept a whole bunch of other charges. When we started, it was just about drugs. It was just about drug charges, which in our jurisdiction is federal or drug charges, and things like theft, break and enter, those types of things are provincial charges. So we have on our team an agreement that the federal crowns and the provincial crowns will work together on our cases. So once the Crown Attorney screens eligibility, it's then passed to the treatment provider. We screen for things like addiction. I will tell you the only, and this really surprises people who are new to drug treatment courts, the only reason we will turn down, pretty well the only reason we will turn down a client is if they are not deemed to be medium to high risk for recidivism. We do not take low-risk people in. You may or may not be aware of the risk needs responsivity model, but that is a model that we follow. And basically, if you have high risk, high needs, you need high intensity of service. So the reason we don't take low risk of recidivism people in is because we will make them worse within our model. Some drug treatment courts take low, but they don't take high. But the drug treatment court model provides intensity. And the statistic is that if you provide intensive treatment to high-risk individuals, you reduce their recidivism by 19%. If you provide the same treatment to the low risk, you increase their recidivism by 4%. So if I bring low-risk individuals into my drug treatment court, and I will tell you that all of the assessments that have been done for the past 5 years in our program, every client fits high risk. When the types of clients that other people in other treatment programs and everything want to turn down, when we present ours to our staff, my team goes, oh, so they're one of our people. People have given up on them, so they're our people. That's who we serve. If we bring low-risk people into that treatment environment, we will make them worse. So drug treatment court is meant to be high intensity, high supports for the high risk of recidivism people. And when you are looking at the criminogenic needs, you can look it up if you're not familiar with the risk needs responsivity model. It's a model that they adopted in the United States. It was created in Canada. But when you look it up, you will see all the criminogenic needs, and these are needs that we have to address in treatment and in drug treatment courts. But when you get to, when you get to the addiction factor within this model, it is equal to, having a substance use issue is equal to the top 4 criminogenic needs combined. So, this is why we're doing this. So they're deemed eligible from the Crown. Treatment screens them to make sure they actually have an addiction and they are actually on the higher risk level. And then if they're deemed eligible by both, they come to court and they plead guilty. Yes, we do have a plead guilty to your charges, and they are entered into the drug treatment court program. And in our model, and I'm not saying I love that part, but in our model, they plead guilty. And when they graduate or leave the program, whatever way they do, that is when they are sentenced. I want to be very, very clear. Anybody who completes the program will not be sentenced to incarceration. Ever. Most people who spend any significant time in the program, even if they do not graduate, because graduation is not the gold standard, change and stability is the gold standard, being connected and part of community is gold standard, and there's lots of things that we can talk about with success factors. But even if they've spent significant amount of time but did not meet the graduation requirements in our program, they do not go to jail. This program exists because jail does not work. We do not see any circumstances under which sending people back to jail when they complete the program, if they graduate, would be acceptable or helpful. It will make them go backwards. Jail is university for drug use and university for crime. And if the opposite of addiction, and there's lots of evidence to say this, is connection, jail is designed to disconnect people. Jail is also designed it actually creates higher trauma impact, because trauma is about power over you. You think about it. If somebody was raped, they had power taken away from them. Someone else had power over them, and they go to jail, and that just, it reinforces it. The searches, the lack of movement, the no voice in their own lives. And these are things that cause addiction. Addiction isn't caused by drugs. These are things that cause addiction. So anyway, I know that we are running out of time, but I started late. So basically they come, they are brought into drug treatment court, and everything starts. Treatment starts immediately. We then do a full biopsychosocial assessment, determining what the treatment plan will be. The clients start coming to court weekly or twice weekly. And before court, we have a pre-court meeting in which every case is discussed in front of Crown, defense, treatment, the judge. Everybody is there. And we make some decisions about what might happen. Treatment is the one that provides the progress report. And the decisions that are made there are tentative because the client hasn't yet spoken to the judge. And in court, the client speaks to the judge, treatment gets up and speaks, and all of the clients are there for the whole session because this is a group therapeutic process. So they're all learning from each other. We give sanctions, we give incentives. Those are all things that are within our model and are documented well. We surround clients with supports. We have a core program, but we individualize our program. We work really hard to get people on opioid substitution. In Toronto, our main substances, we don't consider alcohol or marijuana. That is not something, our courts weren't designed for that, and we don't give that any consideration at all. We do in treatment if it's impacting their functioning, but we don't from a legal perspective. Those are legal substances. We mostly deal with methamphetamines and opioids and stimulants, methamphetamines. And our primary substance use is about 50-50 with some overlap of substances such as crystal meth and fentanyl. So the overdose situation and the drug use situation and the pandemic influenced adulteration of substances is really, really, really huge. I will say we have a minimum stay in our program of 12 months in order to complete. Most clients are there 18 to 24 months. 12 months is a really short period of time to engage and produce change. And the clients have their own pace. And addiction is a chronic relapsing condition. We never, ever, ever, ever punish for use during our treatment program. There are, however, some consequences for not using. When you think about this, we ask clients to come to court and report to a judge that they have broken the law. That is why trust and having consistent staffing within the court makes a lot of sense. They report it, and as long as they're honest, nobody punishes them for it. So I will end with this one thing. The most important thing is therapeutic rapport. In a treatment environment, all of the evidence going back to a study in 1800 somewhere called the dodo effect, basically says that regardless of how well you are trained in whatever modality you are trained in, if you do not create therapeutic rapport, you do not have success. And therapeutic rapport isn't something you do once. It is something that I call it deposits and withdrawals. Everything we are asking clients to do to change is a withdrawal from their bank account. And they can't manage that. They go bankrupt if we haven't consistently made deposits into our relationship, our therapeutic bank, shall we say. So much more to say. I'm going to end there. Thank you very much.
Thank you, Robin. Thank you so much. So I will keep just one word that you said. We said many important things, but I want to keep this word because I want to move to Lord. You said that this is a court, that one basic component is trust. So the client learns to trust the powerful authorities, and these powerful authorities trust an addict. Let's go to Lord now and say, is this something that is usual for the traditional criminal justice system, Lord? We don't hear you. Please unmute yourself.
Okay.
Great.
Thank you very much. And thanks for inviting me to talk. I'm particularly pleased to be here because I've actually been to Cyprus. My father spent the last years of his life in Limassol. So it's, even though I'm not actually physically there, so I can't get to see it again for the first time in 30 years. It's a privilege to be here for this university. I started practicing law in 1987, and I was and continue to be actually as zealous a defender as Justice Barnes was a prosecutor when he eventually came on board. I first started to question the traditional outlook in terms of criminal justice and people who were offending. Early in my career, when I first started, I had a couple of my mainstay clients who were heroin addicts, and they living in downtown Toronto. And I remember the first time that after achieving some measure of success with their charges, and I can't remember what they weren't necessarily drug charges, but whatever they were, it was the commission of a criminal offense in order for them to support their drug habit. And I remember working very hard and getting one of my first clients off on some charge. And 3 days later, I'd get a call. I'm back in custody. And I'm thinking, well, how is that possible? I mean, we beat the charge, or we didn't beat the charge. Maybe I lost the case. The client served a sentence. They've learned from their mistake, and they're not going to get in trouble again. Except what was driving the trouble was not necessarily a desire just to cause trouble. It was the inescapable illness that they were suffering from, which was that they had to use. And that was my first exposure to what we call, the revolving door of the criminal justice system. Someone goes in, not because of malice, but because they have to feed an addiction. They go to jail. And then when they get out of jail, they're right back in again, because even if the deterrent effect has been valuable in terms of the crime, you can't deter an addiction. You can only, I don't think you can even really cure it, but you can manage it. And I as a very young defense lawyer, I began to learn, and it was shocking to me at first, some truths about what was happening in our criminal justice system. The other thing was that these same clients and many others would ask me as a lawyer, can you just, the next time you see me, hand me some drugs? Like as if I had access to these things. I wouldn't have known where to get them. Even though I had drug dealers as clients, I still wouldn't know where to get these things. But they would ask me to bring this into the jail. And it turned out that it didn't matter whether I did or not. And of course I did not, because I didn't want to end my career very shortly after I'd started it. But another reason why they were back in jail very quickly after getting out is because of the fact that not only did jail not deter the addiction, it didn't stop the drug use. Drugs are just as prevalent, if not more so, within our penal institutions. And I don't think it's any different anywhere in the world than it is in Canada. So I was looking at a system that I was involved in where the most common penalty, even for simple possession of a drug, was jail. And so we weren't deterring and we weren't stopping use. And the other thing we were doing is we were filling the courts up. So in Toronto, we have 5 basic level courts, criminal courts, that deal with various criminal charges, depending on the geography, what part of Toronto the person is charged in. But there was only one drug court. In fact, there still is only one drug court. And it's 114 court in the old City Hall in downtown Toronto. And it's almost a surreal experience practicing law in 114 court back in the 80s and the 90s. You would get in there, the bullpen where they keep the prisoners is right beside the court. And it was jam-packed full of people who were there on drug charges. And then they would usher in about 5 or 6 of them into the prisoner's dock, and you would go to speak to your client there, and they'd be, you could even hear the bullpen where there'd be 30 more people out there. And this happened every single day. And it was in that context in the late 90s that I met a young, zealous prosecutor by the name of Kofi Barnes for the first time. And although he had the attitudes that he's told you about when he was a prosecutor, I even got the sense, even back at the beginning, that Mr. Barnes, as he was then, was a realist and was someone who, you know, we did so much plea bargaining, and the prosecutors and the defense lawyers had to do it because the system could not accommodate trials for all of these people who were being processed. And then so that brings about a second concept in the traditional approach of criminal justice to drug use as well as drug addiction. And that's the assembly line. So it's not just a revolving door, it's an assembly line. And you have all of these people coming in and all of these people having to get out because we can't accommodate. In my early years of practice, I spent 2 days once on a marijuana possession charge. I mean, that would be unheard of today, not just because marijuana is now legal in this country, but because if we spend 2 days prosecuting simple possession of marijuana, as Jennifer Graham told you earlier, what are we supposed to do with the high-level traffickers and the murderers and the rapists and all of those guys who we're trying to save society from when we're spending days on this sort of thing? And then I had occasion from time to time to actually go to the places where my clients lived. And I can't remember why. And it's not the kind of thing that we do anymore. There was a smaller bar back then. And but occasionally I'd have to serve a document or get an affidavit or something like that from a client. And I would see some of the conditions in which they lived. And they're abysmal. And I had clients who had no place to live at all. And in that context, so to get back, Dimitri, to the question you asked me about trust, how can there be any trust in the system? You live in an abysmal situation. You are part of an assembly line. If you go to jail, it's because of something you cannot control, and nobody's doing anything about the reason that put you in jail. And even going to jail, even going to the penitentiary, in Canada, the penitentiary is 2 years or more of a jail sentence. Anything less, you're in a provincial reformatory. And it's considered a big, huge leap if you're going up the criminal ladder to move from the provincial reformatory into the federal penitentiary. But I had clients who graduated to the penitentiary, sometimes for drug offenses, sometimes for other offenses, although substance abuse may have been the reason why they got to where they are. And when they got there, 2 years, 3 years, 4 years later, they had plenty of access to drugs, and they were just as addicted when they got out as they were the day they got in, and they were therefore just as likely to commit crimes on the day that they got out as the day that they went in. And so years before there even was a drug treatment court in Canada, I began to see the futility of this process. And the other part of this is that we thought that deterring drug use by jailing people or by the traditional model of prosecution would decrease crime. That offenders or would-be offenders had to know that if you commit a crime, you're going to go to jail. And so to scare people into not committing crimes or not using drugs or not feeding their addiction, the thought of going to jail for a long time is gonna stop that, and therefore they're not going to commit crimes. That's the theory. And the other thing is, of course, if we send them to jail, they're not going to be able to use drugs, and then they won't die from overdoses. And we know now, in the midst of the opioid epidemic that we're in, that drug use has not only become problematic for the destruction of life and the in the social sense, but the destruction of life in the actual sense. And Robin touched on this in her comments about now so much is laced with fentanyl and synthetic opioids, and which it takes such a small amount to kill. And you'd think that would deter people. I could die. But we have people who are not just, cocaine addicts who maybe might be exposed to cocaine or heroin laced with fentanyl, but we have fentanyl addicts. The thought of death, the thought of incarceration is not as bad as the life that they are living or the illness that they are suffering from. A lot of the crimes that I've been involved in defending have been crimes that have arisen from disputes between drug dealers. Drug ripoffs that result in robberies, drug ripoffs that result in killings and murders. In fact, a very large percentage of certainly my criminal practice has been involved with crimes that emanate from disputes between drug dealers or drug users. And why is that? Because if you get ripped off as a drug dealer or a drug user, you can't go to the police. And you can't go and say, usually the police only get involved if it goes to the level of murder, because they got to do something about the bodies that are showing up. So if you're a drug dealer, how are you going to manage when you can't go to the police if someone rips you off? Well, you got to be the toughest, most violent drug dealer on the block in order to survive, because there's no regulation, there's no police, there's no law that protects you because you are a criminal. And so it's not just, Robin said, and she's quite right, that prison is university for criminals. You learn to become a better criminal. But life on the streets and the illegality of drugs creates more crime, because you have to be a better criminal. You have to be more violent. You have to be more tough to live in that world. So, which brings me to something I'm going to read to you, and you may not immediately guess where this is coming from, and I'll tell you when I finish speaking, and we may even have a photo somewhere of it, but I don't want to show it until after I read this. So someone in Toronto said the following: "Our support includes caveats like fully funded social services, but yes, this is an opportunity for Toronto to be a leader in recognizing that drug abuse is a public health issue, not a criminal one. But not charging people is hardly a cure-all. We haven't been charging people for simple possession of all drugs since November 2020, and yet we received 1,300 more calls for overdoses in 2021 than we did in 2019. It's the fentanyl-laced product that is killing people. A close friend of mine lost a daughter, so we need to look hard at safe supply." The author of those comments is not some defense lawyer like me or some treatment provider like Robin.
Lauren, we'll have a photo. Wait, let us upload. Let's try to upload the photo.
We're gonna see the photo here with that guy. So there it is. So that is James Raymer. He is the chief of police of the Toronto Police Force, or service, or they're called now, who said what I just wrote. And in fact, you have the chiefs of police in Canada calling for decriminalization and calling for an alternative approach to drug use, because the police, law enforcement, is recognizing the futility of the former approach. So I'll end there to let you know that it's not just radical, do-good, bleeding heart liberals who are on board with this approach to dealing with the problem of substance abuse and addiction. It is, in fact, it goes right up to the levels of chiefs of police. And that's my perspective. Thank you.
So thank you very much, Lauren. I think according to our program, we should have one short break right now, right? So I think we can follow this line, and we can come back in 5-6 minutes. Is it okay? So I think for me it's 12:50. What about, yes, 5 minutes? Okay, is it okay? So we can, because we have lots of questions.
Great.
Not only from Greece and Cyprus, but also from Botswana and also from South Africa. So get ready in 5 minutes. Okay, here we are again. So we have a number of questions. I will try to address more of them and ask you about those. So let's see, and some discussions also that I have received. Let me start with this. Don't you think that drug courts, drug treatment courts, are soft courts? Don't you think that if I imagine my prosecutor, the prosecutor in my country, either in Cyprus or Greece, saying, yes, good for you, you do well, you're fantastic. It's embarrassing for my criminal justice system.
Can I say just maybe I'll go first on this, just to give this perspective. I have, as a defense lawyer, said to some of my clients, you might be eligible for drug treatment court. And the response I get is, I don't want to do that. That's too tough. I can get time, so I can plead out tomorrow and get time served and be done with this. But to spend a year, 2 years, having to work this hard, going to court every single week, being tested for use, all that kind of thing, that's tough. I think that's tougher.
This is important to say that this is not an easy way to go.
No.
Yeah, what I'll say is that I used to be a prosecutor, and I was shocked as how hard it was, and I used to be a drug court judge, and I was shocked at how, by that time I knew, how people had to fight and to struggle, and when I was a prosecutor, many people would come to me and say exactly what Lauren said. I'd rather go to jail. You see, the problem is, what I learned as a prosecutor is that what I should have done was I should have learned about addiction first. If I learned about addiction, then I realized that a lot of the assumptions that I have don't apply. And that is what I wish I've done first. Right? It is not easy at all.
So what you suggest right now is that, what you say actually right now is that if we are participating in the criminal justice system, lawyers, judges, prosecutors, when we start, we know more about addiction, then we respond better. Is this what you say?
That's what I'm saying. You don't have to become an addiction expert. As a lawyer, when you're doing a case or a judge, you learn about the case before you do it. Well, the same thing, you learn about addiction. That's why whenever we go and do our overseas training, because of the experience of some of us, one of the very first things we do is we do addiction. Because once we understand how addiction actually works, then everything makes sense. And then we are also better to develop a program that will meet our objectives. In fact, I can say that the drug treatment court program actually became one of the most safest programs in terms of public safety, and at the same time helping the individual. Anyways, I don't know. Yeah.
I would say two sentences. Soft may be the opposite of tough, but kind is not the opposite of tough.
Yeah.
This is a great line. Yes, I can understand this. But, also, I'm thinking that from what I've read in the chat and the discussions we have in our countries, we're Mediterranean countries, right? So we will see that and we will discuss it later about the international project that you have establishing courts and helping other countries to develop therapeutic jurisprudence in their systems. There's one question here that says, what is this question comes from a teacher from Botswana, South Africa. who is not a lawyer, he is not a therapist, he has nothing to do with the criminal justice system. Mr. Mudong Mutsakula, if I pronounce it well, and he says, what is the benefit of treating addiction as a medical problem rather than a criminal problem? So I think you already have answered to that. But can we answer with 2 words in that? What is the benefit? Since addiction and crime, and I add to his question, addiction and crime have a very problematic relationship, right? So why don't you leave it where it is? Let it stay in prison and let them go decide, the clients decide, the convicts, the prisoners, whatever you call them, let them decide on their own if they want to undergo treatment or not. When you ask them prison or treatment, this is not a free will decision. So can you please give me 1 line for this or 2 lines for this?
Leaving it in the criminal justice system does not work and does harm. The medical system works much better, and the principle is to do no harm. So if we want to have healthier people, healthier communities, healthier families, then incarcerating people based on addiction will harm all of those systems. But treating them medically may help, and it definitely will help save lives.
If I could add to that, I would ask a question back. Do we not all have the same blood running through our veins? Are we not all humans first? So why are we saying this person deserves to be here or this person deserves to be here? Shouldn't we be looking to help humankind when given the opportunity to do so? And as Robin said, going to jail, that there's no help in that. There's a place for people who deserve to be in jail who've been convicted of serious crimes. Absolutely.
And now the person who asked this question is a medical officer, right?
No, the person who asked this question is a teacher.
It's a teacher. Oh, okay. Because there's another part of the question too where she says, well, it's almost as if the person was asking, well, how come you force people to make a choice?
No, that was my addition.
I see.
Yes.
I see. Okay. Because what I was going to say,
something that comes from people that they are lawyers.
Oh, I understand, because I was going to say that it's voluntary, and at the end of the day, unless somebody through therapy gets to a point whereby they want to actually do it themselves, they are not going to succeed. So that's where the therapy comes in to help them find that self-motivation in the end, right? So that's what I was going to say to that.
The one thing I would say is that, when I was a law student, one of the first things you learn when you take criminal procedure, criminal law, is, what is the point of the criminal law? It's the protection of society.
Right.
So the question really is, how do you best protect society? Do you best protect society by addressing or even solving the reasons why people commit crimes? Or is it to let more people commit crimes and spend more money and have less protection of society because there's more people out there committing more crimes because they didn't address their health issue?
So let's go a little bit to a few questions that they're very precise and concise. For example, there is one from Mr. Kalogiros who says, Mr. Dust Barnes, can you please see this question? Is asking, from your experience, do you consider if there have been a number of accused that they have tried to deceive the system.
Of course. I mean, again, you have to understand addiction, right?
The question, I think, sorry for interrupting. The question here is this, because we have this issue in Greece, and I know that
right.
The question here is, if an accused has the opportunity to choose prison or drug court treatment, he may say that he's, and this question maybe can be answered from both of you and Robin, can we say, well, I'm a drug addict.
Right.
So I want to go to the drug treatment court. Well, he's not a real drug addict. He's not drug addict at all. So he pretends. So he manipulates the system.
There are two sides to the two parts to the answer. Okay. The first part is what the drug treatment court itself does to make sure that it finds out whether a person is an addict or not. Right. In Canada, we have an elaborate process by which the prosecutor will get information on the person. We have a system in place whereby the treatment provider will assess the person. We have a system in place for some drug treatment courts where the police will give input. And probation will give input before an assessment is made as to whether or not the person is appropriate. And even after going to the program, there's even additional assessment over a 30-day period or a period of time where treatment providers get to know the person and so on and so forth to find out whether they are suitable, right? So that is a systemic component of it. The next part of this is this, right? The way the drug treatment code is set up, you can indicate to Robin and lie and say that you are a drug addict. That's fine. But what you're going to find out is that the moment you get into the system, they will find out. There are all kinds of ways in which the system is built to find out, right? So people don't get away with that. It doesn't happen in practice. And actually, I used to worry about that as a prosecutor. And that's why you have that holistic intervention. It's amazing. And that's why people say, hey, Your Honor, I've changed my mind. I want to go back to jail.
Robin?
So,
first of all, experience. Can you have someone in your program and he will behave like he's an addict for 18 months?
Okay, so first of all, because this is related, I'm going to make one statement to say people manipulate the system, and guess what? We do too. Manipulation is not a bad word. That's how we manage. If I come onto this and I smile or I frown, it's a form of manipulation. So let's put that aside. People behave to get what they want. So I want to say it's also okay for people to come into the program saying, oh, I really want addiction treatment, and all they want to do is get out of jail. We expect that, and we're fine with that. The job of drug treatment court is to take people from external control to internal control. Now, would somebody come into the program who's not a drug addict? They could. It is very hard for them to get past our eyes, but sometimes we see it off the bat, or we question it because we're experienced clinicians. So one of the things that we have in our program is a 30 to 60 day assessment period.
This is important. Please, can you focus on that? Yeah. Because in our system, sorry for interrupting, for example, as far as I can say right now, because we have questions related. We have someone who says that this person completes the DSM-5 test, and therefore he's an addict. So this is it. And I always argue that the DSM-5 test has nothing to do with the assessment that you go. So can you please tell us a little bit about this?
Yes. Okay, so when a client comes into drug treatment court in our program, basically if they're meeting requirements, we're seeing them 5 days a week. Secondly, when they plead guilty, as a counter to that, we allow a 30 to 60 day assessment period in which we are seeing if we can work with them. They are seeing if they can work with us. And if we are not good enough at our jobs to figure out if somebody is addicted by seeing them 5 days a week and giving them 30 to 60 days, then we shouldn't have our jobs. But if we did find out that somebody in that 30 to 60 day period, that somebody is not addicted, then we can say, we are going to strike your pleas and you're going back into the regular system. But I can assure you that I have never seen anyone who isn't addicted show up and go through all of this treatment stuff just because they want to get out of jail. And even if they did for a little while, we've probably helped them in some way, because addiction treatment isn't about substance use. It's about all of the many other things. It's about trauma and relationship and complex issues and everything. But I've been running the drug treatment court for, and before that, addictions programs. I think I became an executive director in a treatment center in 1999. I have never seen anyone come and stay in an addiction treatment program, no matter what benefits it gives them, if they didn't have a serious substance use issue.
Thank you, Robin. But I want to continue with you because I have a question from Dimitra Thiveu, who is the director of the residential therapeutic community of Kethea in Greece. And she has a question addressed to you and says, is it possible to integrate and work, the drug treatment program as such, to integrate and work with clients that are a member of residential communities?
So, yes.
We know that you want the person to stand on his feet, right? So not to be somewhere locked. It's not locked, but anyway, this is the idea.
Yeah. So, yes. So therapeutic community model, we don't have a lot of them left in Canada, but we do have some. And we have utilized therapeutic community models within our drug treatment court model. So, for instance, the principles of addiction treatment is that you provide the least intensive intervention first, and then you build yourself up. Sometimes when a client comes to us, they have had so many treatment episodes where they have not seen significant change that we send them immediately to a residential treatment program. And that could include a therapeutic community residential treatment program. So what we do is that we assess their needs. So somebody who's homeless, for instance, have long histories of addiction, have had many tries at addiction treatment. Maybe that's the best first option, or in the middle, or if they're not doing so well and not being able to maintain, we utilize those. Another program in Canada, they actually send people to an addiction, a residential treatment program right from the beginning and get people started off in that. So I would say, yes, we can integrate. I do not think, however, that it should be the only intervention, because clients need practice before they're done completely with the addiction, with the drug treatment court. They need practice living in the community.
Thank you.
That's hope.
Justice Burns, there is a question for you. Mrs. Pridzi, Olga, is a very experienced court reporter in trial courts, criminal courts in Greece, Thessaloniki. So she says something, she says when she has also an experience with investigation and investigation drugs. So she says, someone comes and says, I want to go for treatment, comes to your court, and you talk about consent. Is this consent really informative? Because this person is an addicted person. Does he really understand what he says at the moment? Is it the free consent?
Right. What I'll say is the way in which in our system, and I'll talk about a system in a second, in our system, if a person wants to go into a drug treatment court program, that person would do it after they've received a lot of legal advice, right? So they will know what they are getting into, they will know what they are signing into. And also, once they get into the program, most programs, actually all programs in Canada now, have what you call an escape clause. So you remember how Robin talked about this 30 or 60-day period. It is a period during which where they have to assess whether they want to do the program, because you may say you want to do something. Once you get in, you see whether it's going to work for you or not, right? And at the same time, too, the program is trying to assess and see whether you're suitable. You know, so at the end of that period of time, whether you plead guilty or not, the plea can be struck if you're not interested, and then you leave. But you always would do it with legal advice, and you always will have that window to get out if you want.
Thank you. So something that comes now, there's a question, I think Jennifer can answer this question. So we'll have some people that they ask, what are the recidivism rates? And do you have any statistics, or what do you think about that? I mean, someone undergoes a program and completes the program and graduates. What is after? I mean, do you see him? Because Lorne was talking about the revolving door phenomenon. So what is the answer to that? We say that reduces the revolving door phenomenon. But is it real? I mean, have you seen this data?
Stats are really challenging for us. In my court in particular, that's something that we're working on. We're still kind of a baby program, if I'm being honest. We started in 2016. So that's definitely something like hard stats that we're working on. But that being said, I can say that while we had our little break, I actually had an opportunity to speak to one of my colleagues. I think it's since 2016, we've had 45 graduates. And as I mentioned earlier, only 3 of them incurred further charges after they had graduated. And of those 3, 1 came back. So I'm going to take him out of it. So we're looking at 2 out of 45, and that's 4%. So 4% of the people who graduated incurred further charges.
Okay.
Right. And one last thing I was going to say is that you could check out the Calgary Drug Treatment Court. Not all drug treatment courts in Canada have resources to evaluation all the time, but the Calgary Drug Treatment Court does, and it has a lot of stats. And I mentioned it in my talk. Most recent stats that will show that it's a high core group and will show the recidivism rate, which is pretty impressive.
I'll just add to that. I do know some statistics, but the problem is, like, you cannot even compare from one Canadian drug treatment court to another, because there's different types of drugs, different types of clients, those types of things. I do know that out of the Center for Court Innovation in the United States, which is an apolitical center, which isn't really part of what you might call the drug treatment court industry in the States, they see success as a 14%. Now, the statistics may change since the last time I saw this, but 14% decrease in recidivism is seen as actually a pretty great success. And the reason that is because if you look at 14%, that has a tremendous impact on the criminal justice system and the costs. But what we do know is that there is decrease in recidivism, but also among the people who are, how do you say it in verb, recidivizing among the people who do have more charges. Overall, their charges are less severe.
I see.
And if I could take that opportunity to remind you of the example I gave of our current client, right? In 2 years, even though she came in with 66 charges, 19 different informations, she has incurred 0 new charges.
Yeah, well, I mean, if we take that and we compare with what Lauren said before, I mean, 4 days later, he called him and said, I'm back again. Okay.
Yeah.
Let's see, we have another question from Mrs. Savopoulou, who is from the National Addictions Authority of Cyprus. And she says, in practice, first of all, there's one question about substitutes, actually, if you have substitutes in your programs. I see Robin laugh and I know why. And we have another one that says, I mean, from Natasha, who says, in practice, who is responsible for case management and taking care the logistics? And how much time of their court time do judges spend on the program? Which I think we have to say something on that. It's a very important question.
All right, Robin, you want to do the case management?
I'll do the case management.
And the substitutes, please.
The substance use was
like methadone and stuff, and
the substitutes. Okay, I'll start with case management. So case management is assigned different people in different drug treatment courts are assigned case management. In my case, case management is done by the treatment provider. So we are therapists and case managers combined. Case management so when a client is released to drug treatment court in Toronto or in Ontario, they are put on a bail order. In Ontario, probation officers do not supervise bail. In Vancouver, when a drug treatment court client is released, then the probation officers do much of the case management, and treatment just does treatment because probation officers supervise bail. In many jurisdictions around Latin America, Caribbean, probation officers are doing most of the case management. So it depends. In our jurisdiction, the treatment provider does the case management. We like that because the treatment provider, as opposed to the probation officer, has no legal authority over the client. But whatever works, whatever resources you have available. Substitution therapy. We wouldn't survive without it. We believe that denying it is actually a major ethical issue. This is medication. And we look at it as we would never deny somebody insulin for diabetes. We are not denying people addiction medicine for their addiction issue. And I think there was a question earlier, maybe I'll answer it in all in one. When the criminal justice system says that it's not acceptable to have people on like opioid substitution or therapy, we are basically saying we are denying people health services, and we are saying that we have not moved beyond the very old impression that that is still using. If you're on methadone or Suboxone or Sublocade or naltrexone, and we're even doing some other medications now because the fentanyl issue is so big that things like Cadian we're using on top of methadone because people won't be able to stop using. The bottom line here is these medications save lives, period. We have an overdose epidemic and they save lives. all of the evidence shows that that is true. And my thing is, and most of us say, if a court of law is not where you hear evidence, then where is it? And this is medical scientific evidence. I'm a bit strong on that.
Just
right.
once you want to say something.
There was a question about how much judicial resources are used. Is that
Yeah,
the
yeah.
question? Yes. In Canada, anywhere from half a day, a week to 2 half days, right? That's about it. The judges who do drug treatment court do other things. They have other cases. So that tends to be
So the judges who do drug treatment courts, they are real judges.
they're real judges. Yeah, they're real
They
judges.
do other real things.
They do other real things.
They
Yeah.
do really send people to jail.
They're regular judges. They do other things, but you know, they'll spend about maybe half a day in drug treatment court, just doing drug treatment court, or maybe a week, or sometimes it's 2 half days, but usually half a day.
Can all the judges do that?
Do what?
Can all the judges do that?
Well, you know, technically all the judges can do that, but what we try and do in Canada is try and make sure that you have a consistent judge over an extended period of time, at least a year, sometimes 2 years at least, right?
But it's not forced, right? I mean, somebody.
No. It's not forced. No. I see what you mean. No, you have to have a special temperament for something like this. You have to have the right characteristics. Otherwise, you're going to mess up the program.
So thank you. I want to go to one more question. I think it's addressed to Lorne. So we have some people here that they are lawyers and they are frustrated and they say, okay, we love your system, we love what you have, we want that, but how can we do that when people are incarcerated for marijuana and they are sent to jail? So before we said in this panel that you have legalized marijuana in Canada, right? Well, I remember that we also said that the first drug treatment court was back in 1998, right?
Yeah.
Right. At that time, marijuana was not legalized. Okay,
That's
marijuana was just lately legalized. So, can we have a harsh criminal system, a harsh criminal law, and also to have drug treatment courts in our system? Is it possible?
Yeah.
I think we can see the answers already.
I mean, keep in mind that it's only been since 2015 or 2016 that marijuana was legal here in Canada. But in any event, you know, marijuana was never a way to get into drug treatment court, anyways. So alongside,
in our system does.
What?
In our system does.
Yeah, I know. But sentences for drug offenses in the 90s, and even today certainly for trafficking offenses, are very harsh, to use that word, and they continue to be harsh. And drug treatment court exists alongside that sentencing regime. It is, I mean, you have to have legislative change in order to allow this to exist. So, for example, in Canada, we had until the Supreme Court got rid of a number of them, but we had mandatory punishments for certain drug offenses, mandatory minimum jail sentences, which would mean that a judge would have no choice but to send someone to jail for certain offenses. Well, with, you know, thanks to people like Justice Barnes, you know, the criminal code of Canada had to be amended to permit an exception to the otherwise mandatory sentence of jail for someone who is in a treatment court or a drug treatment court. And so But for those who are not in the court, the harsh reality, and again, I'm going to use that word that you used, still exists. So these two, it's simply a recognition. So for, and let me, perhaps I can say this. The drug treatment court is not a court for anybody who is facing a jail sentence for a crime related to drugs. So for example, if you are engaged in a large commercial enterprise of selling, say, methamphetamine, you're not going to get into drug treatment court. It's not even going to be available to you. So one can have, and you can probably tell that I'm not an advocate of it anyways, but you could have a system where certain offenses related to drugs and the use of drugs or the sale and distribution of drugs are still harsh, but there is still a recognition that those who are committing even those kind of crimes only because of a medical or health issue should not be dealt with in the same ways. These are parallel responses of the criminal justice system to different kinds of issues that result in offenses. I mean,
can I say for
okay.
Yes, Justice Barnes. Can I say, so you can add probably
sure.
better than me, that can I say that we have a court? We see a big door that says criminal court, but also there's another big door that says drug treatment court. So what I get is that you can choose, if you're eligible, right, where to go, but it doesn't mean that when you have a traditional criminal court, you cannot have a drug treatment court, right?
Right.
Is it right?
Right. And what I was going to say to you is, our drug treatment court was set up 24 years ago. 24 years ago, our criminal justice system was not much different from yours. The only difference may be that, you have a continental system and we have the common law.
The system is common law and it's very hard.
But in terms of the way we dealt with drugs, the fact that there was no opportunity to get real treatment, all those things, that marijuana was a crime, all those things, that is the way it looked in those days, 24 years ago. Right. So that's why I say I've traveled and said, there's always a way, because it was not easy in those days, but now it's a bit different.
I think I will take this. I mean, Jennifer, I don't know if Robin, you wanted to say something about that. No, Robin, yes, you want to say something.
I think that the thing is that the legal context does matter. In Canada, we have two statements in our criminal code that allows for drug treatment courts and allows for mandatory minimums to be waived if people go to drug treatment court. In the Caribbean, for instance, in Jamaica, as we worked with them to establish their whole criminal code, they have pages and pages that establishes drug treatment courts. So the thing is that it really depends on your legal context, but whether we're talking Jamaica with pretty well all of the policies and procedures of drug treatment court are written into their law, or Canada where there's two statements that are hard to find, it's still possible. You just have to really have the will and work with it. And the whole question about a harsher system versus a not harsh system and how we start it. Yeah, drug treatment courts are an industry in the United States and their system is way harsher than Canada. So yes.
Your Honor, you want to say something? I thought you...
Oh no. It's okay, because I was about to say that, when the drug treatment court started in Canada, we didn't even have those two comments, those two things that Robin talked about, right? So we started with zero, right? And maybe we'll get a chance to talk about it. But
we will talk about this right now.
Yeah,
right
okay.
now we will go there, because actually what we have here from the comments, either from Dr. Savridou from the University of Paphos in Cyprus, Mrs. Rousaki Adonia from Kethea, which is a prison therapeutic community for women. What they say, and also from other people here in our chat, that say, well, our systems have some very harsh provisions about possession of drugs, any drug, including marijuana, right? Greece has very modern system now, but still in practice is not applied as far as I know. Cyprus still has a very strict legal system, but has also some roots now to therapy. I believe that these are good ways to see the thing, that when the system really accepts somehow even the phrase, the word therapy. Okay, so Robin said that words matter. But all of them, they say, okay, your system proves that they are successful in Canada. What about us? And how can we fight with the stereotypes? And what I'm going to do? And honestly, Adonia says, where should I go? To whom? To say what? How can I promote a pilot project? What can I do? Is it just an imagination? So can you please give us your international experience now to feel a little
Okay, Robin, do you want to go first, or should I?
Yeah.
I don't know if this is the time. You go ahead.
Yeah, I can go first. I mean, first of all, I would say that in Canada, the Federal Department of Justice allowed for drug treatment court to start in Toronto, and we were a pilot project for many years. And you can do a lot under a pilot project, because that's where you gather your evidence, you gather your understanding. And so there's less at stake when you do it under that umbrella of a pilot project. When Kofi said, I'm not sure, Kofi, if you said you've been to 20 countries or something like that.
Yes.
I think I'm at 10 or 11, maybe more. And so where I have traveled is the Caribbean, Jamaica and Trinidad especially, but then throughout Central and South America, everything from the more Americanized Mexico to the more European type Argentina, and everywhere in between, Colombia, Guatemala, whatever. So there are a few things that I always advise. Number one, the advice is to us, those of us who go into other countries to promote this. We are just here to share what the principles are, what the things are that make it a drug treatment court, and the things that you have to be aware of because it's not a drug treatment court if it exists. And those are very high-level principles. Beyond that, we are here to not tell you how to do it or what to do, but what our experience is, what our failures are, what our learnings are, how we have developed. In any country, you have to consider the culture, the social context, the legal system, the health system, the treatment system, and I would say the drug scene, like who's using what overdoses are like, all of that kind of thing. And how do you adapt this model, which has worked in so many different spheres, to your system? But drug treatment courts push systems. So there were many more people against drug treatment courts in Canada and certainly the United States than there were for it. Like, let's just accept that. And so, yes, it's a struggle. I would say that developing your model, trying it out, gathering the right people around you, and that inner circle of who's going to be doing it is important. But the outer circle of networks and supporters, whether it's universities, professors, community agencies, some people say business associations even, because it'll make it better for them. It doesn't really matter who they are, but gathering that around, and any social change or legal change or health change is painful. So we have to, we have to know what the evidence is. And evidence is qualitative and quantitative. We tell your story. Tell the stories of people that has made a difference in their lives. And understand what each person's role is, understand what your eligibility criteria are, what goals are there, like what is success factors, and reevaluate. Even if you don't have the resources to do formal evaluation, constantly reevaluate. And I would also say that the team, the treatment, court team, judicial team, you have to get together and argue it out kindly, appropriately. But we still do that. We still do that. And cross-training is extremely important. If a judge or a crown doesn't understand addiction and motivation, and if a treatment program doesn't understand the legal context, then we're not a drug treatment court. And I will kind of end my part with this. Recently, we had a death. We have deaths in drug treatment court. We have a huge fentanyl problem. And quite frankly, the last 3 deaths we had are people who use stimulants, but the supply has fentanyl in it, and they've had fentanyl overdoses. And we reflected on this 32-year-old man with severe mental health issues and severe drug addiction issues, an immigrant from an African nation. And as I was processing the death with the court team and the treatment team, I said, look, we all agree that every system he has come in contact with has failed him. Some of the systems are broken, and some were set up that way to be against these people, or to be against people of color, or people who have poverty or trauma, or women, or all of these things. They've been set up that way. But you and I are part of those systems. We are part of those broken systems, whether it's legal system or school system or the health system. But you are not the part of the system that is broken. You are the part of the system that prevents this broken system from breaking the people you're working with. So what I would say is, it's a tough battle. You can get ridiculed, you can get criticized, but if you are passionate and you believe in the evidence, you can be the part of the system that brings healing and not destruction.
Okay. I'm going to say I accept everything and adopt everything that Robin says. I take it to be my own. And I'm not going to repeat that. Now, what I'm going to do is, everywhere we travel to, usually we are met with the same question. Our system is different from yours. Our system is so hard, it's so difficult. These are all the problems. It's not going to work, and people cannot wrap their head around it. So let me give you a sense of a typical training session, right? Just to give you a sense, because we fly down, and with everything that Robin has said, we try to develop a training session for people to understand the principles and give people a sense to start to develop their own program before we leave, right? And so we try and create the house. That is, the house is understanding what addiction is, understanding what the key principles of drug treatment courts are and how they work, right? Understanding what kind of issues that you're going to that face treatment providers. What are some of the legal issues that are going to face the practitioners? Give people a chance to hear the story of people who have actually been drug treatment court graduates talk about how to plan the drug treatment court itself, dealing with public perception, dealing with soft on crime issues, arranging resources, mapping resources, have a physical demonstration of how a drug treatment court actually work. How do pre-court meetings work? How do the court process itself work? How to build a multidisciplinary team, do all that kind of stuff. And then when all that stuff is done, then we have the participants who are usually decision makers and other practitioners go and break out into groups and develop a drug treatment court program for the country, right? And they will identify the problems, the solutions, and so on and so on and so forth. And we tell them, don't look at the problem from what your legal system, from the perspective of your legal system right away. Take everything that you have learned about how the program is actually supposed to work and the principles, and through that prism, look at your legal system and see how it works. 100% of the time, and this includes continental places. I've done this in many countries. 100% of the time, the people in that jurisdiction have found a way that they did not think existed before the program, and they've developed their own program, and then they take it to decision makers. And that's the reason why I have great faith that there's always a way where you can do it in a way that suits you, and in accordance with what works for you.
So I think with this way, thank you very much. We have already answered the questions that were related to how do you think we can establish a pilot program in our system. So these are questions asked by Danai Rafti, who works in Kethea, also from, I think, from another person who's working there. It escapes the name right now. Oh no, I think it was Rusaik as well. And also Olga Prizzi was asking the same thing. And also lawyers from Cyprus asked the same thing. So what you say right now, what you said already, is that without us knowing that, when we look at the principles, and when you have these workshops with us, because I suppose that if we decide that we want something like the Canadian drug treatment court model, which we have to say it's quite different from the American drug treatment court model, and if we decided that we want to implement a pilot program as we proved in the research that we conducted, you will come to us, right? Justice Barnes, Robin, Lauren, Jennifer. So we will come.
We will gladly come to you, and you know something, and it's not just because we want to see Greece, which is fabulous, Cyprus, which is fabulous, but because this actually works, right? And it's so heartwarming when you see it work.
So you will come to us, and you will come to us because drug treatment courts matter, right? Okay. Jennifer, why does it matter for you?
I'm glad you put it to me that way, because I'm going to answer what specifically to me, kind of taking my my hat off a little bit. But I just want to say I didn't start where I didn't start with the ideas or thoughts about a DTC like I have now. I was very apprehensive. I too did not believe that it would be successful, even though our court had just become established. Me personally, I didn't think it was going to work. But listening to the people who came before me, like all these wonderful co-panelists I have here, and the treatment providers, I very quickly learned and was educated that addiction is a medical issue that's caught in the criminal justice system. And learning that was really like a turning point for me to understand how I can be of assistance to the clients. I don't call them accused people, defendants, or anything. They're clients, even though I'm the Crown Attorney. They're clients in the court. And it matters to me because they're people. As I said before, we all got the same blood running through our bodies. They deserve a chance, just like everybody else. And if this is the path that they choose, then I am there to support them the best way that I can in the constraints of my role. So it matters to me. Every person matters to me. So to me, it's worth a chance.
Thank you. Lord?
It matters to me because, as Justice Barnes said, for one thing, it works. But, you know, in the criminal justice system, like any system, and certainly like any justice system, has to realize at a point when the way we've been doing it for all this time, does it actually work? And, you know, if I've learned anything in 35 years of criminal law practice, it's that we have to adapt and we have to change because the ultimate goal is the protection of society. And drug treatment courts are a way to better protect society. So that's my answer.
Robin?
So first of all, most everybody are somehow impacted by addiction. There are people listening today who have been impacted by addiction. There are people listening today whose family members have been impacted by addiction. You've seen it in your lives. And drug treatment court clients typically don't have all of the supports that some of us do have. I say that there's no them and us. There's just us. But the difference between some of us is that we have been able to get our needs met in a different way. As a citizen of my city, my country, I believe that I have a communal responsibility to those who haven't, for whatever reason, been able to get their needs met. And that's all we're all trying to do. We just want to be happy. And that is why drug treatment court clients and any others use. They use to feel good, to feel better, or to feel nothing at all because they've lost hope. So it matters to me because I believe one of my purposes in life is to bring hope. And I will tell you also that I don't think I've met a drug treatment court client that doesn't have a history of trauma. And if I were to start drug treatment court or treatment systems over from the beginning, I would start with a trauma-informed lens. And that would make all the difference. And that would be so humane. So it matters to me. I carry the drug treatment court and all of the clients I've been able to work with, I carry their stories on my heart as a privilege and not a burden. And this is such privileged work.
Thank you, Robin. You know, you make me think that in our societies, we think that trauma is weakness. So, and with the law guys, you know, the people that we go before the courts or we're judges or prosecutors, we have nothing to do with this work. So, because Justice Barnes started somehow like this, his discussion, his talk this morning. And I remember that he said that that time, back in 90s, he couldn't see this word, right, Justice Barnes?
Yes.
What is trauma? Where the criminal law says about trauma? Tell us, why does it matter? Why you managed to realize, or how did you manage to realize? Why does it matter for you?
You know, as somebody who helped start the first drug treatment court, my first response may be a bit off, and then I'll go into deep, right? It matters because the first reason why it matters cuts across philosophical lines. Drug addiction is a health issue. Science shows it. A system like drug treatment court, when done properly, helps the individual get better. It's better for society because it reduces crime, it makes society safer. It saves money, and it makes the system more efficient. It reunites life. It creates more happiness. It benefits society as a whole because it benefits the individual. So whether you're liberal or conservative, there's a benefit. On a personal level, I have been a prosecutor and I've been a judge in the drug treatment court. I have seen people who have come through the court system the first time, high as a kite, lost. They've lost everything. Nobody thinks they've got a shot. I have watched them with support fight. I have watched them have strength. I have watched them get better. I have listened to them and see them reunite with their children, with their family members. I have watched them get jobs and be productive members of society. I have watched them help others. Now, ladies and gentlemen, if that does not touch you to the core, I do not know what is. In fact, amongst judges, many judges are reluctant to do drug treatment court. But once they do it, they don't want to leave because you see the resilience of the human spirit. So even when you forget about all the money and all the which is important, just to see human beings thrive, it's amazing. It's an amazing experience. And we owe it to not just set up the court, we owe it to learn how to do it right. Because when we don't, we can cause more harm. We need to learn how to do it right. So that is why it matters to me, because every life, just like mine, matters.
Well, this is very important to say, that if we will be able one day, all of us, to say that life matters to all of us, those that we serve the criminal justice system. So I will take the happy note and I will say that I will ask you, can we make it in Greece and Cyprus? Tell me.
I will speak. I will speak for myself. When you are asking questions, from the question, I can see some of the problems that you have.
Yeah.
I've gone to countries, several countries, and based on what you've told me, I just don't see how you cannot make it in Greece and Cyprus. I mean, I am so confident that soon, in a couple of years, I'm going to hear that you guys are doing something, because I can just see it happening. And I don't want to speak for everybody here, but you know that all of us here, and they'll speak for themselves, we are prepared to come and learn from you. We are prepared to come and share what we know. We're prepared to come and learn from you, and then you develop your own stuff in a way that suits you best.
Well, I'm thrilled, because when we conducted this research and we said, why don't we start with a pilot treatment program in Cyprus and in Greece? And everybody said to me, who's going to teach us how to do that? I said, I bet Canadians will do. So now you say yes. So it's fantastic. Thank you for this. We've learned a lot today. And I think that what we see from the chat, that people are very enthusiastic about the way you presented the reality of the drug treatment courts. I want to thank all of you again. And what I believe, not hope, I really believe that slowly we can start cycles with seminars that will address certain issues and will be addressed to professionals, either judges or prosecutors. We didn't talk about the policeman role, the police role in these cases. It's very important. We didn't talk yet about juveniles and what the kind of population. We have many issues that we can talk from this discussion. We can take different topics and discuss them further. And even the role of the defense counsel, the traditional one and the not traditional one, if he loses money, if he does not, all these are discussions that are concerns that may be trivial for some people, but not for others. So I will end this conference, if you allow me, and I will say that to me, being with you and having you here, proving actually that what we suggested 2-3 years ago for the pilot courts in both Greece and Cyprus was fantastic. I think now I feel better that we can do it. I think many of the people that are watching us tonight, they feel that maybe there is hope. I know that you're certain because you have experience on that. The only thing I want to do is to wish that every one of us, the people that they work with us in the universities and people that they are in treatment communities, treatment centers, everywhere, will try to promote a little bit the idea. So not to expect society to change, but to expect us to change society, our society. So thank you very much for being with us. Thank you.